now discuss on property law. Personal properties are subject to UCC rules. Okay. Now, real properties are not subject to UCC rules. Common laws will apply for properties, real properties. Okay. Common law will apply for real properties. Now, what is a real property? If a property is, kind of attached to a specific location, such as land, buildings, or items that are permanently attached to the land, that would be treated as a real property. Okay, wherein a personal property is all tangible properties that are movable. For example, equipments, furnitures, automobiles, all these are considered personal property. Now, there could be some fixtures which are attached to a particular real property, then that's considered as a real property. Okay, so now when it comes to understanding this real property and personal property, let's understand this. Let's say land is a real property. So anything grows on the land is a real property, right? And once it is not, part of the land, then it becomes a personal property. For example, let's say trees in a forest. Okay, trees in a forest is a real property when it is in the forest. Let's say the tree is cut down and it is made into lumber. Okay, wood. Okay, these are personal property. Let's say these lumbers are used for making a house. Okay, then of course this becomes a part of real property, and the wood here becomes a real property now. So this is how. So basically, real properties classification is based on the use, intention of the properties, how it is attached. Okay, and what is the depreciable life and things like that. All right. So there are various ways that ownership of a personal property or a real property can happen, right? By means of purchase or taking possessions, right? Somebody who finds something becomes the owner for that. For example, capturing of a wild animal, and that becomes possession for him, one who catches it. Okay, production of property, you can make a property, right? Receive something as a gift, right? Or something as inheritance. This is how you get your properties. Now, let's say, um, with regards to real properties, okay, transfer of ownership happens on a deed. Now, what's a deed? Deed is a document of title used to accomplish the transfer of ownership of real estate, right? So as we know, as per the statute of frauds, this needs to be in writing. Anything with related to real estate needs to be in writing. Okay, and the writing should have the name of the transferor and the transferee, often called grantor and grantee, description of the property, intention to transfer the title, signed by the transferor. Okay, and may include or may not include price or depreciable life. So, what are the kinds of or types of deeds? Okay, there could be something called quit claim deed, or we call it as is deed, wherein the owner, okay, transfers a property to a grantee without considering or without giving any warranties. No warranties is transferred. Okay, no warranties is transferred. He's saying that I'm transferring this property as is. Okay, with all faults. There could be some deeds which could be grand deeds. Okay, grand deeds are what? Okay, here the transferor is guaranteeing. Okay, is guaranteeing that during his tenure of holding the property, there's no claims against it. Okay, he's not guaranteeing anything prior to his ownership. So let's say if he bought it from 2010 and he's selling it 2020. Okay, under grant deed, the transferor claims that there's no defects for this property during my period 2010 to 2020. All right, so what's a warranty deed? Warranty deed, guarantees full rights. Okay, so even prior to transfer, for example, 2010 to 2020. Okay, this is where it get transferred. So transferor not only gives warranty for this period, but he covers the warranty for the whole life of the property. That's what is a warranty deed. So that's what everyone wants. Right. Then it could be a present interest. Okay. Any claim of real estate or real property, including title, security, and lease. So when it comes to real estate law, okay, the highest law estate is called fee simple absolute. Okay, has most of the rights in it. Okay, um, then something called fee simple defeasible, subject to conditions of the subsequent event or life interest. Uh, so interest whose term is usually the life of the holder, but may not be measured by the life of the other. So probably the transferee can enjoy this during his life, may not be to somebody after his death. A leasehold interest, very often in lease agreements where the lessor is transferring lessee, okay, a lease agreement, okay, where a lessee could use it, okay, and lessor ensures that certain rights are given to him. So under the property law, the highest authority is fee simple absolute, and the least one is leasehold interest. A transferee, okay, should protect the title of the deed because that's really important. So therefore, he can get a title insurance wherein the insured is, basically the transferee is ensuring that the title of the property deed or the property is valid. Okay, so such a policy compensates the insured if a defect is existed at the time the transferee acquired the property. So basically, the insurance company go through all valid reasons, seeing that if there are any liens, encumbrances, or easements on the property, only then they will basically provide this particular insurance. So therefore, you're basically safe about the title of the property. Marketable title is the title of real estate that are free from encumbrances such as mortgages, easements, liens, and defects. So, a transferor and transferee, okay, does not need to record the deed unless it is for the claims against third parties. So between them, deed is enough. Okay, deed would be enough. But why would you get it recorded? Because there could be other third parties who might, basically will raise a claim on this. So in order to protect against other third parties, that's when the deed must be registered or record under a particular appropriate governmental office. Okay, so most of the states in the US are notice raised jurisdiction states. Okay, so anybody who earlier raises a claim will win. Okay, so that's how it is. So let's get into one particular example to understand this particular thing. Jack originally sells his home to James, okay, giving him a valid deed, okay, so which James does not immediately record. Jack then sells the same home to Joshua, providing an identical deed. So now both James and Joshua has the deed, and both of them record it. Okay, the party with a priority in a notice raised jurisdiction depends on whether who basically recorded this deed. Okay, so let's say the originally it was first transferred to James, right? So if James has recorded this first, okay, before Joshua, of course, James wins. Okay, whether Joshua knew it or not, James wins. Okay, whether Joshua did not know, James wins. Or let's say Joshua recorded first before James. Okay, both of them had identical deed, but Joshua recorded it first. Okay, if Joshua knew that this lady or Jack had originally sold to to James, if Joshua knew that, then James wins. Let's say Joshua did not know, okay, that this property was initially sold to James. In such case, Joshua wins if Joshua records first. All right. So, what are adverse possession? Sometimes, possession of a land gets to an unlawful owner due to certain circumstances. By probably open possession, you uses it for a reasonable period of time. He demands an ownership in the real property, okay, or hostile possession or actual possession, okay. Um, so there are certain issues with relates to easements. So easements are what? Non-possessory interests or rights established in the same fashion as an adverse possession. So the major one is the right of way easements, where if you let certain people, basically pass through your property for a certain period of time, they would raise a claim, okay, for right of way easements. So there are different types of easements. One could be right of way easements, and certain things are easements for services. Okay, an electrical company, okay, electricity providing company can probably, fix in a box, okay, that sits in your property. You can't say no to that. Okay, this is called easement of services, used for utility purposes. Okay, easement of another one is easement of light and air. Okay, so basically, let's say you have a property here. Okay, you have a property here and you have the road here. Okay, so now you have fresh air and light and everything. Let's say somebody else buys a property just in front of you and makes a very big building there. Okay, very big building there. Of course, your access to the road, as well as the fresh air and light is basically covered by this big building. So of course you can raise a claim against this, saying that you're you're not getting light, right? So this is called easement of light and air. So let's understand the right of way easements, right? Or let's say, okay, let's say there was a particular main road here. Okay, main road goes like this, and this is the property of, let's say, A, this is the property of B, this is the property of C, and this is the property of D. Or let's say A has been using the property of C for basically accessing the main road. Okay, accessing the main road. Let's say A was using this particular property of C. So later, A can, of course, claim uh, basically a claim on this way. Okay, this is called right of way. Okay, right of way easements. So therefore, if C wants to, sell his land, probably it is difficult because of these easements lying there. So therefore, what they can do is that, sit down, talk it over, and probably, get this particular piece of land registered to A uh, for a money, so that at least C's rest of the property would be, uh, you know, basically without any easements. So many people can own the same property. That's called concurrent ownership. Okay, when the property is owned by more than one person. So the major ones are tenancy in common. Okay, we call it no right to survivorship. Okay, tenancy in common. usually happens when you have two or three people or more than that owns the same property with separate interests in the same property. Okay, so simplest form of concurrent ownership. Interest can be different. Okay, upon death of a co-owner, the interest would be distributed to their beneficiaries upon uh, as per their will. Okay, now joint tenancy is different. Now this is more restrictive arrangement. Okay, so there needs to be equal interest so as to time, title, interest, and possession. Okay, each person may transfer interest without the consent, but if they do so, they lose the survivorship, right of survivorship. Okay, so um, tenancy in entirety. Okay, each spouse has the right of survivorship. So basically, husband and wife owning the same property. That's what we call it, tenancy in entirety. So in order to understand this joint tenancy and tenancy in common, okay, so we need to understand that tenancy in common, let's say A and B on a particular property, okay, and C, or let's say three people on a particular property, and let's say C dies, okay, uh, and so C's ownership will be transferred to his son X, okay, and X becomes a joint tenant, okay. So we're talking about what? Tenancy in common first, okay. X becomes tenancy in common again, okay. Now let's say in case of joint tenancy, let's say we have three owners A, B, and C, and let's say C transferred his right to X without the consent of A and B. Basically, uh, X will lose the joint tenancy rights, right of survivorship. Okay, so which means what? Later, if B dies, A becomes the sole owner. Okay, and X does not get anything of the B. All right, so now, when we discuss the mortgages, now mortgages are basically security interest in the real property, isn't it? Okay, so as per the statute of frauds, mortgages needs to be in writing. Okay, wherein names of the mortgager. Okay, mortgager is who? Basically, one who takes the mortgage, and mortgagee is the one who gives the mortgage on. Okay, so the bank is the mortgagee, and the borrower is called the mortgagor. Okay, so basically in the writing you need to have names of the mortgagor and the mortgagee, description of the property signed by the party to be charged, of course, uh, in order to enforce against him. Okay, so you need to record the mortgage. Okay, why would you record it? Again, to basically get a claim against other parties who might raise a claim later on. Now, if the debtor or the mortgager, the borrower, okay, defaults on the loan, okay, the mortgagee can foreclose the property by taking judicial action. Okay, so mortgagee can sell the property, okay, and probably a new buyer comes. Okay, a new buyer might take, um, might not be accepting personal liability on the sellers, the borrowers, liability. Okay, or the new buyer might assume mortgage. Okay, or under novation, the new buyer takes all liability, even personal liability, on the mortgage. So in that case, the seller goes free. The original borrower seller goes free. All right. Now, when we discuss about leases, now leases are when property is leased by the owner. Okay, the owner gives a right of use uh, property to a lessee, basically, and Um, of course, this needs to be mentioning the names of the lessor and the lessee, description of the lease property, lease payment amount, lease terms. Okay. So the landlord, the lessor, gives three kinds of rights to the lessee: right of possession, uh, right of warranty of quiet enjoyment, okay, and warranty of habitability. The lessee can basically assign, okay, so by assigning a lease, the transfer of the balance of the lease to another person, giving the assignee both the right and use of the premises and obligation to pay. So basically, let's say an original lease was for 10 years. Uh, the original lessee used it for 5 years and then basically assigned it to X for the rest of the 5 years. So now the X will have to basically pay the obligations for the rest of the years, and of course he has the same rights as the original lessee. You could also sublet it, okay, where let's say X was the lessor, Y was the lessee, okay, later Y gave it to Z a portion of the lease, okay, and so therefore portion of the rights under contract of the sublessee for a payment for the to the lessee. Okay, so basically, let's say X gave a building on a lease to Y. Let's say Y doesn't need all of this portion. Probably this portion is given to Z. Okay, so now Z becomes a lessee and Y becomes a lessor there. Okay, so lessee is has to make the payment to the Z has to make the payment to Y, the original lessee. Okay, and Y is responsible for all of this towards X, the lessor. When it comes to intellectual property rights, okay, copyright law, okay, this is valid for life the author plus 70 years. Now you created this copyright by hiring somebody, then the term is 95 years from publication or 120 years from creation, whichever comes first. When it comes to computer software copyright acts, okay, amends copyright law to include computer programs as creative works. Term copyrights by corporations are business are valid for 75 years from publication or 100 years from creation, whichever comes first. Okay, so you can't, this particular act basically prohibits you against copyright infringements on software. We have no electronic theft acts, criminalizes copyright infringement over internet. We have Digital Millennium Copyright Act established to minimize the international pirating and distribution of copyrighted works. Patents. Patents, we have three kinds of patents. One is utility patent, plant patent, design patent. Now, utility patent is for your invention for useful, usefulness. So this is given for 20 years. Okay, if you find or reproduce a new plant, okay, you get a plant patent that's valid for 20 years. Or you make a design, original or ornamental design for articles or manufacture. Okay, you get 14 years. So basically, utility and plant patents are granted for 20 years. Design patents are for 14 years. Trademarks. Now, trademarks are certain names, words, symbols, or something like that. This is an intangible assets. Okay, this does not have a particular life. This is indefinite life it has. Okay, so initially it is given for 10 years, and then the owner can renew it indefinitely. Okay, giving it right indefinitely. Trade secrets are certain informations formulas, patterns, programs, device, methods. Property right to trade secrets lasts indefinitely, okay, such as KFC's original recipe, okay. Semiconductor chips, often called mass works, okay. Chip Protection Act prohibits taking part of semiconductor chips to copy them, okay, known as mass works. These are protected for 10 years, so you can't really copy the semiconductor chips and copy them. So you are given a protection for 10 years, okay, from the time of registration or application, whichever is the first. That's about property rights. Good luck.